I'm attorney Kelly Longtin from Kelly Longtin Law, and today I want to talk to you specifically about estate planning for franchise and multi-level marketing business owners. Now, franchise and multi-level marketing businesses are often attractive because they offer people the chance to start a small business with a well-known brand and an established business model. However, they present different estate planning challenges than other types of small businesses because the rights and the obligations of franchisees and multi-level marketers are spelled out in contractual agreements. So what is a franchise? That's what I'd like to talk to you about next. When you purchase a franchise, you're purchasing a unit from a company that is already established in a particular industry. And as a franchisee, you're entitled to use the company's business model and their advertising resources and products and receive training and ongoing support from the company to enhance your chances for success. In return, you must adhere to specified business practices and standards. Now, the cost of purchasing the franchisee can be quite high, and there are typically also ongoing fees for support and royalty payments for the use of that brand name. So what is a multi-level marketing business then? In a multi-level marketing business, you benefit from having established products to sell and the use of the company's advertising materials to promote them. You can earn money by selling the company's products and recruiting other sellers whose sales provide you with additional income. Now, multi-level marketing businesses usually offer flexible schedules and they don't require substantial initial costs, though the company may require a minimum monthly purchase of products. Those who have a large network of friends and acquaintances and are friendly and extroverted are more likely to succeed in a multi-level marketing business because those businesses need connections, and it also usually involves presentations of products in order to generate more sales. So how do these business types impact your estate planning? Well, unlike many other types of money and property that you own, an interest in a multi-level marketing or a franchise business may not automatically transfer to your beneficiaries, even if you include it in your will or your trust. Further, if it's permitted to be transferred, it may be forfeited if your beneficiaries fail to meet certain contractual requirements. This is because the transfer of those interests is governed by the terms of the agreement that you entered into with the franchisor or that multi-level marketing company. A franchise agreement typically imposes strict requirements on the transfer of a franchise business. For example, the person to whom the franchise may be transferred must apply for the transfer, and the franchisor usually has the right to either approve or reject that transfer. And prior to granting their approval, the franchisor is going to conduct some background checks and personality tests. They'll review financial personal statements, and they'll check to see if that applicant is on the terrorist watch list, because no one wants to have a bad person or someone without a good reputation and who's not financially responsible representing their franchise. Now, the proposed transferee must often agree to meet certain financial and operational criteria. They have to attend all of the trainings, they need to sign a new franchise agreement, and then they need to also provide a personal guarantee for this business. Simply including a franchise business interest in your will or your trust is likely insufficient to accomplish a transfer of your business interest to your beneficiaries. Now, multi-level marketing agreements may impose other requirements that could prevent your beneficiaries from receiving what you intend. A multi-level marketing contract may specifically state that the multi-level marketing interest may be inherited by an individual or a trust pursuant to a will or a trust or state law. However, it may further state that the person who inherits the business interest must execute a new separate agreement, fulfill all of the obligations under your contract, and abide by all of the company's policies by promoting and supporting the product and motivating and training other distributors. If the beneficiary fails to do so, even immediately, The beneficiary may forfeit the right to receive commission payments based upon your years of work for that multi-level marketing company. And if you haven't done so already, carefully review your agreement to learn the contractual requirements for transferring your interest. It may be helpful to have your attorney review and discuss it with you to avoid any misunderstandings about your rights and your obligations. In addition, provide a copy of the agreement to your estate planning attorney so any desired transfer of your business interest can be incorporated into your estate plan. Now, it's not uncommon to discover that the multi-level marketing business in which you have an interest has not addressed these issues in its contract. If that's the case, you may need to work with the organization's leaders to encourage the creation of a company policy dealing with these end-of-life or incapacity issues. If you're not sure if any of your children or your family members are interested in taking over your business, a family meeting will help you determine their level of interest and prevent conflicts after you pass away. In addition, interested beneficiaries must likely take certain steps to facilitate the transfer pursuant to the agreement. Therefore, you should educate and prepare those beneficiaries in advance to maximize their chances of becoming a successful transferee. Alternatively, you may consider transferring the business interest during your lifetime or choosing another multi-level marketing distributor or franchisee to purchase your interest at your death, if allowed by the terms of your business contract. If you have an interest in a multi-level marketing business or franchise, it's crucial to familiarize yourself with any provisions in the contract affecting your ability to transfer your interest to your beneficiaries, and a copy of the agreement should be provided to your estate planning attorney. Now, we can help you determine your rights and obligations under the agreement and the best way to address your business interests in your estate plan. So just give us a call today to set up a consultation. We can either do that in person, via telephone, or even video conferencing. So I want to thank you all for watching. I'm attorney Kelly Longtin, founder of Kelly Longtin Law, where we provide effective estate planning for everyday families.